Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-5246. Ascension Borgess Hospital et al. Appellant versus Rush Appellee Memorial Hospital 20 CV 01957 et al. Versus Xavier Becerra, Secretary of the United States Department of Health and Human Services. Mr. Hope for the appellants, Ms. Lopez for the appellee, Xavier Becerra.
Morning, Mr. Hope. You may proceed when you're ready.
Good morning, Your Honor. Drew Houck on behalf of the appellant hospital. May it please the court. Congress expressly requires that the Secretary adjust Medicare policy through rulemaking. That safeguard provides the public the opportunity to both understand and comment on potential changes in the law, but it also allows the public the opportunity to hold the agency accountable for deviations from the law. Unless Congress speaks clearly and convincingly to the contrary, courts have long presumed that Congress intended judicial review for such agency actions. Here, the hospitals allege that the Secretary violated that rulemaking requirement, but they've been denied the opportunity to pursue that administrative appeal on the basis of a preclusion provision. They asked this court to decide whether that preclusion provision insulates the Secretary from this express rulemaking obligation under the Medicare Act.
There was rulemaking. There was notice and comment rulemaking, including on the question whether the 2015 only partially audited forms could be the basis for the proportional allocation. So what is it? Your briefs refer again and again to audit protocols. Can you be more concrete about what is it that you believe should have been that wasn't subjected to notice and comment?
Yes, Your Honor. Prior to the proposed rulemaking in May of 2019, in the fall of 2018, the Secretary issued a review protocol to the financial intermediaries that were to conduct these reviews of the S10 worksheets. Those are the worksheets that the Secretary provided, that the hospitals provided to the agency to account for their uncompensated care. The hospitals had filled out those worksheets, providing what they had been told by the agency, they had been instructed by the agency they were to put into those, the uncompensated care. That included any care they had provided to individuals under their charity care policies or their financial assistance policies. What occurred in the fall of 2018, when those were reviewed by the agency's fiscal intermediaries, were many of the hospitals received reviews or audits, as the government refers to those. They drastically cut that uncompensated care from the fiscal year 2015 cost reports. In fact, I believe on I
don't think you've answered my question.
I'm sorry.
What is it that you believe should have been subjected to notice and comment rulemaking that was not?
The review protocol, Your Honor.
And what is the review protocol? You mean the audit procedures that were given to the intermediaries? The review protocol, yes, the review protocol that were given to the intermediaries, that the agency was instructing the intermediaries what uncompensated care was. Because prior to that, the hospitals had been given instructions from the hospital on what uncompensated care was, which included all care they had provided under their charity care policies or their financial assistance policies. But when they provided those numbers were changed on the S10 worksheets. And I believe the government even acknowledged that in the proposed rulemaking that followed in May of 2019. At the appellant's brief on page 10, we quote the government's rulemaking in May of 2019, where the government acknowledged that the audited worksheets show that there are, for 10% of the audited hospitals, there was at least a $20 million difference between the fiscal year 2015. So it's the definition of uncompensated care? That's what should have been subjected to?
We believe so, Your Honor. Again, it was the allegations. We were cut off very early in the administrative process. So we had alleged that the results of the reviews showed that there was a disconnect between what the hospitals had
I understand those facts, and I understand how your clients are concerned about it. I'm just trying to focus on, my understanding from the government is that ordinarily audit methodology is not subjected to notice and comment rulemaking. And I assume that if it were, that you would have cited many cases about that.
That's true, Your Honor. And the cases the government cites to about audit protocol not being normally subjected to notice and comment rulemaking are true. I think the distinction here in this case is we're not so sure that those cases are really applicable, because in this case, we're alleging that policy was changed through the audits, not that the audits.
What policy?
That the uncompensated care that the hospitals have been told they could report prior had a different definition. The hospitals have been told they could report all of their uncompensated care. And that when the government instructed the fiscal intermediaries to conduct these reviews, that the changes on these S10 worksheets reveal some change in policy at the agency level about what uncompensated care was, Your Honor. And that distinction, I think when you look, for example, the government cited to, I believe it's the Dirksen case, that's out of the Ninth Circuit at 1458 and 1459 in the Dirksen case. That case stands for the principle that audit protocol are not normally reviewable and not normally subject to challenges, procedural challenges. But there, the Ninth Circuit commented on the fact that the claims processing rules that were trying to be subjected to notice and comment didn't change the public's understanding of what the law was. They didn't create any new categories of claims or services that could be submitted to the government. We have alleged here that what has happened is that the change underlying these reviews was a change in what uncompensated care could be claimed on the cost reports, Your Honors.
So the claim is not, the briefing sometimes refers to the hospital's perception that it's unfair that only certain hospitals' data was audited and certain other hospitals' data wasn't. That is not the locus of your challenge.
No, Your Honor, it is not.
Because that decision was subjected to notice and comment.
That's correct, Your Honor. It was. And I think at the administrative level, that was certainly part of the larger claim. But on appeal is specifically the issue about the notice and comment challenge we've lodged against the policy change we've alleged regarding the protocol that were before. We think that's really important. And what has changed in this court's prior case law on this is the express rulemaking.
You say, you're saying the words that all sound good, but I have the same question to Judge Pilgrim. What exact policy is it that you think was created or changed that should have been made subject to notice and comment rulemaking? Was uncompensated care, which uncompensated care could be covered? That's what you think was changed?
Yes, Your Honor. Prior to the reviews, the hospitals were allowed to claim they understood that all of the care in their charity care policies and their financial assistance policies was an allowable cost reportable on their cost reports. And after these reviews, we believe the protocol, because of the differences in the numbers on the S10 worksheets that the government audited, that adjusted that. That's we believe, an indication of a change in policy at the level that should be subjected to the merits claim that we have before the board.
Is it the case that the individual audit for an individual hospital, the hospital has the ability to appeal that?
But not in this case, Your Honor. The government's position is specifically because of these reconciliation reviews.
Not for purposes of its use in the numerator or under the statute, but don't the worksheets have other functions for the hospitals? That's why they were available. And so to the extent that there's audits that affect them for their immediate purposes, is there no appeal available to say this was misaudited, or what are you finding here? I think there was an appeal there.
I want to be sure I'm clear with my words. With the worksheets, my understanding is the S10 worksheets were used specifically for this purpose, for the purpose of estimating, in this case, the uncompensated care. But if Your Honor is referencing the cost reports and whether or not the cost reports are generally something that can be subjected to administrative review, The general answer to that question, Your Honor, is yes, they can. The agency issues notices of program reimbursement. It's a reconciliation process. Normally, providers can engage in an administrative appeal of that reconciliation process. In fact, many of the appellants here tried to do so, but the administrative board responded to that by saying it lacked the jurisdiction to go through that because the cost reports at issue, the fiscal year 2015 cost reports, had been reviewed and the notice of program reimbursement had only been issued for purposes of the Secretary's proposed rulemaking under the Factor 3 adjustment. So in this case, Your Honor, I don't want to speak for the government, but my understanding from the board level was that they dismissed those for lack of jurisdiction under this preclusion provision.
I'm not sure I entirely follow, but are you saying the audits were performed only for purposes of Factor 3, not for purposes of the underlying function of worksheets S10?
I believe that's the government's position, that they audited these worksheets, the S10 worksheets, for the purposes of this rulemaking. And I think what makes this case different from the cases this court has previously had before it is the Supreme Court's decision in Alina, which specifically applied the Medicare Act's overarching requirement for express rulemaking. In fact, in the context of this program, the disproportionate share hospital program. And that matters here because what this court said in a different case, in the ACLA case, was that when a statute has an express rulemaking requirement, that might shift the balance in the test that this court applies to decide what congressional intent was to enforce the strong presumption of judicial review. And here we have the reinforcement of Section 1395 HHA2 under the Medicare Act, where that's an express rule requirement. It's an express rulemaking requirement. And there's no language in the preclusion provision at issue, Your Honors, that strips away that rulemaking requirement from the Secretary. It's very specific about what is precluded, the estimates and the time periods. And I think it's also important to reflect on the fact that this court, or that other statutes in the Medicare Act that Congress has provided its clear intent of stripping of judicial review by also not only targeting the unreviewable action, but also targeting the process itself, rulemaking.
I think we understand all of that. And as a general matter, you're correct. If you have a right to rulemaking, you have a right to rulemaking. The question is, you got to have a policy to which you're pointing and saying to the court, that policy was adopted without rulemaking. I mean, it's the Yale New Haven Hospital analysis is, in my view, largely on point with respect to this, but you've got to show a policy with respect to which you think there was an adoption of that policy, it's in place, Elano covers it, and we didn't get a chance to look at it through notice and comment. And I think what we're struggling with is, what is the policy? You say protocols, but protocols with respect to what?
And Your Honor, one of the difficulties in this case, I think that's different from Yale New Haven, is because of the early stages in which we were cut off at the administrative level, we weren't able to fully develop a record on appeal. It was quite literally cut off.
No. Let me tell you the way, at least it's like me would look at this. It's not a hard thing to see that there's a policy there that's covered by the law, and then ask whether that's adopted by notice and comment rulemaking. I'm trying to find the policy to which you're pointing. I don't care whether you were cut off early, late. That's beside the point. You have to show us the policy that you're concerned about that was adopted, and then say there was never notice and comment on this policy. We know we can't get to the merits behind this, but we're entitled to notice it. But what's the policy that you're fighting about?
Understood, Your Honor. I see I've entered my rebuttal time. If I could also continue to answer your question. I think here, again, my understanding is prior to this, the instructions that the agency had provided to hospitals on what they could claim on their cost reports, what uncompensated care was a broader definition than what they provided in their protocol, we think. In their protocol.
How can you only be at a we think stage? Why couldn't you think? How can you only be at a we think stage? Why wouldn't you know that? What the hospitals were told previously and what they were told now?
Because we only have what the hospitals were provided previously, and the government will not provide its protocol. We don't have the protocol. We can't look at the protocol and the rulemaking.
You don't know what the hospitals were told?
No, we know what the hospitals were told, Your Honor.
Well, if you know what they were told before and you know what they were told this time, it seems to me you would be able to discern whether or not there's a difference.
Maybe I can help. It sounds like what you're saying is the hospitals were provided guidance on what counts as uncompensated care, and they filled out the worksheet S10 accordingly. And your supposition, based on the results of the audits, is that the intermediaries were told something else about what counts as uncompensated care.
That's correct, Your Honor.
I have to say, that is not an argument that I gleaned from your briefs, and not want.
That's why I'm struggling with my questions, because we're trying to figure out precisely what it is you're going after.
So it's really, if I understand you correctly, it's the definition of uncompensated care.
Is that right?
Your Honors, I see I'm out of time. We believe so, yes, Your Honors. And CMS transmittals that were provided to hospitals before these, the instructions provided what uncompensated care could be included on the cost reports. But you're right, that's outside of the record in this case.
Well, I want to be clear about one other thing. There are a number of factors that the secretary is to take into account. And the fact that the hospitals received instructions to submit very broad reports doesn't necessarily mean that if an audit were performed and indeed it was determined that all of the care reported was actually provided to the eligible class, that doesn't necessarily mean the hospitals are going to get 100% compensation. I mean, that's been clear throughout, hasn't it? So the fact that there's a difference between what the hospitals reported according to instructions and what the intermediaries said was appropriate in this case could be two different things based on other factors that have to be taken into account. It's not as though that's why it's so difficult to understand what we would be saying in accepting your argument. And I think that's why, at least my understanding of why the panel is pressing you so on this.
Yes, Your Honor. I think that what we're seeking is only the ability to go before the board and press that case. And if I understand—
What case?
The merits of the case. I think Judge Rogers outlined that the government may have a different idea of why the numbers are different, that it wasn't a change in policy and that it was a different reconciliation process that they were going through. That is a possibility for the board, but we didn't have the opportunity to do that, Your Honors.
And now you're saying this is a merits claim as opposed to a procedural notice, failure of notice and due process claim?
No, Your Honor.
Right. Okay, I don't know how else to ask it. And my colleague, Judge Bill, tried to boost up my question, still trying to figure out what the policy is you're trying to get at. And then Judge Rogers said, well, you know, the results look iffy to you, but that doesn't tell me when I'm looking at it, well, what policy is it that he thinks gave rise to these iffy results, iffy in your terms?
Right, any questions, colleagues?
No.
We'll give you some time for rebuttal.
Thank you, Your Honor.
Morning, Ms. Lopez.
Good morning. Sorry, it always takes.
We'll hear you more clearly if it's at the right level, so don't rush.
May it please the court, Carolyn Lopez on behalf of the Secretary. I think it might be helpful to just sort of take a step back to look at the overarching review bar, which has been interpreted by this court in two cases, in Florida Health and in DCH. And there, this court made very clear that any challenge that goes to the estimate, the secretary's estimate, falls clearly within the heart of the review bar. And so, for example, in Florida Health, it goes to the data that underlies the estimate. And in DCH, which did come out after this court's case in Alina, of course, which is the same as the Supreme Court's case in relevant part, this court held that it also barred challenges to general rulemaking challenges to the methodology that underlay the estimate. And that's actually exactly what's happening here. So,
Well, just go with us for a moment. If, we have Alina also saying notice and comment rulemaking, is not challenges to failure to provide it are not necessarily barred. We have the Yale New Haven case, which describes a distinction between a claim that's going after the substance of the estimate and a claim that's saying you have to fulfill the notice and comment rulemaking obligation. So if we were to make that distinction, how would you respond?
No, Your Honor, I would definitely disagree with that distinction.
With what?
So first of all, on a couple of points. So first, Alina was decided before this court's, Alina was decided before Congress set up this entirely new methodology in which Congress both said, so it used to be that dish payments were sort of this retrospective thing that looked at the hospital's actual number, no sort of estimate in the same way that it's done here. And so Alina was about sort of the merits question of whether in that system notice and comment was required. Here we have something totally different. Congress set up a new dish payment system in which Congress says the secretary has to do this estimate on this really time-contracted frame. The estimate is interdependent with one hospital share altering the other hospital share. And at the same time, Congress said there will be no review, no administrative or judicial review that challenges the secretary, any estimate the secretary makes. And so that doesn't mean that the secretary doesn't have to do notice and comment rulemaking. In fact, it's undisputed that the secretary did do notice and comment rulemaking on exactly this question when deciding whether or not this was the most appropriate data. And so there were comments that said both the audit was unfair because you only selected some hospitals. There were also comments that said the audit was unfair because we think that the results sort of varied so much that the protocols must not have been right. And the secretary, in establishing the estimate, said, we disagree with those comments. We think that the audits actually made this data more accurate, and that's why we're picking this data as the estimate. And we know that it's not really that they're sort of, and this is in their own words in both the complaint and in the brief, that but they're not concerned about something happening in a vacuum. What they're concerned about is they don't like their audit results, and they don't like the fact that the secretary chose those audit results as a basis for the estimate.
No, what they're saying is the intermediary, they're alleging the intermediary did something different than the intermediary previously had done, change in policy, and they are entitled to notice and comment rulemaking. I have to be very clear with you. I don't accept your argument on notice and comment rulemaking to the extent that it's inconsistent with Yale New Haven. If a regulated party has a right to notice and comment rulemaking, they have that right. That's separate from the merits of the claim. And you're right, you have a big argument on preclusion with respect to the merits. That's not what their brief is arguing. That brief is very clear in saying we were denied notice and comment rulemaking. I still am trying to understand with respect to what.
So two things, Your Honor. First, I agree with you that I am a little bit confused as to with respect to what, and that as we've been discussing today, they got full notice and comment rulemaking on the issue of what the estimate would be, including whether or not to use these audit protocols.
And is the definition that was given to the hospitals, is it different from the definition that was given to the intermediaries?
So I cannot say anything about, again, because these audit protocols are confidential, but it is HHS's position that the audit protocols are completely consistent with the instructions given to folks, but also more broadly,
the audit only is for purposes of Factor 3. These are not auditing because the worksheets originate for a different purpose.
So and thank you very much for the question, Your Honor. So this is part of the general cost reports that that folks have to turn in, and they were used in this case for factor 3, and that is something that the secretary said. We think this sort of new worksheet came into being around the same time that there was the dish payment change. So it could be used for other purposes, but the secretary has always said, we think this would be a very useful data set for the agencies. And I do want to emphasize that I think one case that's helpful also is the Clarion case that we talked about in our brief. And so the Clarion case says that where there are certain instructions to sort of the Medicare intermediaries that don't actually change the substantive entitlement to payment, those aren't the type of thing that even fall within the notice and comment requirement under ALINA. And that's exactly what we have here, because at the moment—
Why is that? Because they're not a rule?
No, Your Honor, because the secretary could have chosen a different— so at the moment that the audits happen, there's actually no change to the legal entitlement to payment. At that moment, the secretary could have said, you know what, I actually don't like the audit results. I'm going to use as the basis for the estimate for these dish payments some other data source. So the actual decision as to what the basis for the payments would be is in the rulemaking.
Is in the what? I didn't hear. Is in the what?
Is in the rulemaking that set the 2020 dish payments, not in those sort of prior audit procedures, because it's the secretary's selection of that data as the most appropriate data that makes them eligible for payment on that basis.
And I take it that the choice of the 2015 allocation is not just for 2020, that CMS plans to use that going forward.
One small tweak to that, yes, Your Honor, they do plan to use that worksheet S10 data and have continued to do audits, but each year they select a new tranche of data. And my understanding is that they've currently moved on to more recent. So,
but not that, so they're not going to use the 2015.
That's right. They're no longer using
because in the past they picked a year that they used multiple times. They gathered the data and they continued to assume that the proportionate share for each hospital was unchanged year to year, and they're not doing that anymore?
No. So they do sometimes use a year sort of more than once, but my understanding is that they're no longer using the 2015. I believe it's 2017. It might be later, and part of that is because, again, this was a new data source. It was a new type of worksheet back in 2013. And the secretary said from that very first rulemaking, we think this is going to be a great data source. Once hospitals have had a chance to become more familiar with how to submit things, we've given them lots of opportunities to resubmit, and we've got to figure out how to, and usually data is audited. And so we've got to fold that into the system. And then once that got up and running, they've sort of become more efficient at doing that. And so we've moved on to more updated years.
Are you asserting we have that was no change in what compensated care could be covered?
Your Honor, that wasn't the focus of their brief. And so I'm not sure I entirely understand. And so I just want to be forthright that I don't entirely understand their point today, but HHS's position is that the audit protocols are consistent with the instructions given to the providers, but also that's a merits question, that the preclusion of review bar absolutely bars those types of merit questions, whereas in plaintiffs' briefs, they quite candidly say the problem with these audit results is that they tainted, the use of them tainted the dish payments, that they were a component of the dish payments. And so they really are, under this court's functional analysis. And again, DCH is a rulemaking. DCH was a rulemaking challenge too. And DCH, they said it was a slightly different rulemaking challenge, but DCH was a rulemaking challenge that said, we as the hospitals don't like the merger rule. We submitted comments about that merger rule, and we think that the secretary acted arbitrarily and capriciously in not adequately responding to those. And this court said that those are out under the review provision.
But just to clarify, and it was helpful, your answer saying that they don't plan to reuse the 2015 audited data as the in factor 3. But imagine that HHS did plan to use it again. And imagine that the hospitals came and said, we're taking whatever you decided based on the estimate for 2020. But because you're going to use this again, we want prospectively to make sure that the uncompensated care, which affects what we get at the end of the day, was subjected to notice and comment. Would your position be that the preclusion provision bars that claim?
Yes, because the preclusion of review provision bars the litigation in the first instance. So in this court's prior decisions, drawing distinctions like that, the court has always, so in American Clinical 1, this court first held that what was actually an issue in that case was independent of the agency action shielded from review. And it's only after having made that first decision that the court then looked to the type of relief. And in that case, the court said, yes, prospective relief, but actually the one thing we definitely know is no retroactive relief. But it did have to make that finding first. And here, we don't think that there is a way to untangle it in that way. What we're talking about is the data, the Secretary's choice of appropriate data, which is Florida Health. And what we're talking about is the Secretary's methodology of ensuring accuracy of that data, which is through the use of audit protocols that are confidential as all audit protocols are.
How is it a challenge to her estimate if there's no estimate even extant yet? I mean, that's what my hypothetical is trying to separate, is that there's no calculation of any amount.
It's just the rule that's going to govern.
It's just what is the
So I think it's that the way that this court's functional analysis has worked is that you ask whether the type of agency action, so here the type of agency action is, can you use audit results where the audit protocols haven't been published, which again is a very normal enforcement tool to not publish the sort of secret sauce of exactly how the audit works, because then you can have circumvention. And so that type of prospective relief would be saying it's invalid for the Secretary to choose this type of data as the basis for their estimate.
That's not the nature of their claim. The nature of their claim is whatever overarching rules or protocols you're following, we're entitled to see in notice and comment rulemaking. They're not contesting, and I agree with you, preclusion blocks that. You're wiping away Alino, and Alino's big. I mean, it says it's not just rules, it's all kinds of policies in there. It easily fits there if I can figure out what the policy is that they're concerned about. But for you to say because the rule that they want to see or know that you're following will later be used to get results that they can't see doesn't mean they're not entitled to notice and comment rulemaking on the rule.
No, Your Honor, just briefly to go back to Clarion, as far as I understand it, as they're arguing it today, they are saying that something happened at these audits that they didn't like. And at the moment that the audit actually happens, there's no change to their legal entitlement to payment. And when there's no change to their legal entitlement to payment, ALINA doesn't apply in the first place.
No, I see. I just disagree on what you think they're saying. They're not saying, they're saying you followed something that was different than you previously did. The results may or may not be good, but we're entitled to know what it was you followed, and that's subject to notice and comment rulemaking.
There has to be.
They may not be right, but you're overstating what their position. They are not. I read the brief again just before the case. They are not saying we're entitled to challenge the merits of what you did. They are saying we're entitled to know the protocols that you followed. That's all.
No, Your Honor. Well, so first of all, as we explained in our brief, that it would be highly irregular to force an agency to make public their audit protocols.
But the what? Say that again. The what?
Highly irregular to force an agency to make public their audit protocols. And they know that. So essentially what they're doing is forcing the agency to no longer use audits on the data. And that is the best methodology that the agency has found to ensure data accuracy as part of this estimate. And and again, sort of the tenor of, they're not actually injured at the time that the audit happens, because so a lot of audits, a lot of Medicare audits, they happen after payments have been made. And so they are actually asking for the payments back. And those are really different than these types of audits where nothing happens to them until the secretary says, I actually think that this is the most appropriate data. I see that I'm above my time, but if there are further questions, I'm happy to answer them.
No.
Judge Rogers?
No, thank you.
Do these audit protocols go through internal government review, OMB or OIRA or anything?
I apologize, Your Honor. I don't know, and I don't want to make any misrepresentation on exactly how the audit protocols are created.
Right.
Thank you very much.
Council had used up time, but we had used up some of it. So as I told you, we would give you some extra time. We'll give you 2 minutes for rebuttal.
Your Honor.
First, I think the use of the word audit just changes the character of what we've alleged happened. What we've alleged is that the rules were changed in the course of this. So if the government is saying it has the right to tuck rule changes, requirement changes, or policy changes to the substantive requirements into its audits, and thus make them protected from a lineup and make them protected from HH2's rulemaking requirement, I think that's a real stretch.
I hear you, but I also have to say, to be fair, I did not understand that to be your claim before you stood up here today. Is there anywhere you would point us to in your briefing where you made clear the nature of your challenge? You've just articulated in a much more useful way. But I had a really hard time understanding what you meant by audit protocol.
Right.
And it's not going to be possible for us to reach that claim unless it's been presented.
Fair enough, Your Honor. The difficulty that we have faced is, I think you've heard, is we face the problem of not being able to reach the merits of these claims at the early stage of being dismissed on jurisdiction. So in paragraph 4 of our complaint before the lower court, we mentioned that we are specifically targeting the policies of the review protocol. I believe that's on JA28 is paragraph 4. And we allege that the failure of the policy to go through notice and comment rulemaking is a failure under HHA 24. We don't get into the definition of uncompensated care in that paragraph.
Or anywhere.
I'm sorry?
Or anywhere
That's correct, Your
specifically.
Honor. That's correct, Your Honor. It's outside the joint appendix. It's outside the record because we simply couldn't get into the minutes. I think one of the other concerns we have about what's happened here for the providers, I see I'm out of time, Your Honor.
Thank you.
Case number 21-1182, Christopher Garvey, petitioner versus Administrative Review Board, United States Department of Labor. Mr. Garvey for the petitioner, Mr. Fuentes for the respondent, Mr. Keneally for the intervener.
Good morning, Mr. Garvey. You may proceed when you're ready.
Good morning, Your Honors. May it please the court.
My name is Christopher Garvey. I'm here as a petitioner. I'm very grateful for the opportunity to be here this morning and to answer your questions, albeit without the representation of counsel. I'd like to start, if I may, by summarizing the issues that bring us before the court.
You have to speak up just a little bit.
Sure. I'd like to start by summarizing the issues that bring us before the court, and I'd like to reserve 2 minutes for rebuttal, if I may.
In terms of the question whether the conduct at issue here was domestic or foreign, you only, I think in your reply brief, do you mention that the statute is primarily a securities law and that therefore because the protection is protection of the integrity of the US stock exchange, the locus of the conduct is domestic? Did you make that argument anywhere before the reply brief?
I think so, Your Honor. I think from the outset, I've made clear that the way to interpret Section 806 is in the context of the greater regulatory scheme to which it contributes, which is Sarbanes-Oxley. I think I make the crux of where the board went wrong, Your Honor, is precisely in interpreting this statute as a domestic labor law focused exclusively on the employee and the terms and conditions of employment. But I think in doing so, Your Honor, it has failed to take account of the fact that Section 806 is an integral part of the Sarbanes-Oxley Act. And Sarbanes-Oxley, Your Honor, passed in 2002 in the wake of Enron, WorldCom, and Global Crossing, is unmistakably a securities statute, an anti-fraud measure. And it contains numerous provisions, sure, but all of those provisions contribute to a single purpose, which is anti-fraud. And so I believe in focusing exclusively on the employment-related aspects of this, the board has failed to give any weight whatsoever to issues to the protected activity and the nature of the protected activity, or the conduct by the subject, the covered entity subject to the prohibition on retaliation. I would argue, Your Honors, that compensation to an employee is not here the focus of this statute. Compensation to an employee is similar in this case to the reward to an informant. It serves a purpose, which is to encourage people with firsthand knowledge of fraud to raise their hand and step forward. But it is, to look at it exclusively as a domestic labor law, I think entirely misses the point, Your Honor.
You focused on the fact that you came to the United States, on the fact that communicated with the legal department in the United States. I think the ALJ determination is in the passive voice about who made the decisions that you allege were retaliation. Were they made by Morgan Stanley US, or were they made by the Hong Kong subsidiary? And what were the decisions that you allege constituted constructive discharge or retaliation?
Sure. Those decisions were all made here in the United States. At least they were approved and initiated. My supervisors, I reported directly while I was located in Hong Kong. I've never challenged that, Your Honors. But I reported directly to people here in the United States, in New York. And the retaliation that I suffered, one was a reduction in pay. That reduction in pay was authorized and agreed here in it was agreed in New York by Morgan Stanley's chief legal officer.
Was it initiated in Hong Kong?
I guess it's a complicated structure. The pay, Morgan Stanley's pay structure is such that all decisions around pay are controlled in the U.S. I believe it would have been a combination. It's in the record, and the reduction in pay was agreed in order to quote unquote deliver a message.
Who are you quoting?
This is, I'll find the reference, and if you don't mind, when I come back on rebuttal, but it's in the joint appendix, Your Honor. It's an email that was exchanged on Christmas Eve, December 24th, 2015, between Morgan Stanley's legal department's chief operating officer, James Murray, Chris Odell, who was one of my direct supervisors, and they refer to a conversation between, I guess, approval by Eric Grossman, who is Morgan Stanley's chief legal officer. But it comes at the behest, I think, of a gentleman by the name of Bill Park, who is Morgan Stanley's chief international general counsel. The other retaliation I suffered, Your Honor, was a threat to future promotion prospects. That arose in the context of raising concerns about the manipulation of the investigation into the facts that I had raised, and that retaliation, that the comment that I got in response to raising those concerns was, well, you should be careful because the very people who you're accusing of being involved in the wrongdoing are the very same people you need approval from to obtain promotion.
All right, I think I found the email that you're referring to, which I believe is on JA 64, Thursday, December 24, 2015. It says, Phil wants to reduce Garvey. This is from James Murray.
Yes, correct. That's correct.
To Odell. Phil wants to reduce Garvey. Thinks flat is the wrong message.
Correct.
I'm not sure that that's send him a message, but thinks flat is the wrong message. Eric not opposed. And Phil is where?
Phil is the international general counsel. He's based in London. And then the final piece of retaliation that I think this court should take account of is the intimidation of counsel that occurred post-termination of employment here in Washington, D.C. I retained the services of, at the time, Katz, Marshall, and Banks.
I think the difficulty there is that retaliation, that you were no longer employed, and to see that as retaliation by an employer in the course of employment is the basis of the ALJ's determination was that it's not employment retaliation, it's something else.
Correct, Your Honor, and I believe that's exactly the mistake, because they looked at this as purely an employment-related issue. I think the retaliation, the interference with an employee's ability to obtain representation and to file their claims under Section 806, I would argue is distinct from the merits of their claims. To allow employers like Morgan Stanley with hugely disproportionate resources an extrajudicial path to determine which employees are entitled to file suit and to obtain representation at counsel in connection with doing so, I would argue is contrary to the spirit and intention, if not explicitly, of Section 806A2 itself, but it allows an extrajudicial path to determine who can sue, which I would argue, Your Honors, is an obstruction of justice, and I don't believe that would have been within the contemplation of Congress, either for this statute or indeed any other statute, whistleblower provision that the Department of Labor administers.
one of the major difficulties is this notion that Congress would have contemplated a Department of Labor administered whistleblower protection scheme to apply to employees whose place of employment, in your case, is in Hong Kong. The Department of Labor would, under your reading of the statute, have to investigate theoretically whether people in Hong Kong were taking retaliatory action against you. They'd have to look at the, claims of, in a classic case, claims whether whether adverse action was taken based on the quality of the work or not. It's a very fact-intensive and extensive kind of inquiry that can happen in retaliation cases. In the Department of Labor, no indication that Congress thought the Department of Labor was going to be conducting overseas investigations.
That may be the case, Your Honor, but I don't believe it's any different, frankly, to cases here. I think what the language of the statute, in my opinion, clearly and unmistakably extends the coverage of Section 806 to foreign companies with a class of securities registered under Section 12 and/or affiliates whose financial information is included in the consolidated financial statements of the issuer. That's crystal clear from the language, and many of those companies, Your Honor, don't have domestic employees. To accept the board's interpretation of that language would involve significant redundancy. And I think because the language would apply to a significant number of companies who do register securities under Section 12, but who don't have domestic employees. And I believe when confronted with two competing interpretations of the same statute, one of which involves significant redundancy and one of which doesn't, I believe this court should adopt that interpretation which avoids significant redundancy, particularly where, as in this case, the interpretation that avoids significant redundancy is consonant with the overall goals of the statute, which, again, I argue are to prevent and detect and prosecute fraud, to protect U.S. investors here in the United States. I see that I'm over my time, Your Honors.
Thank you.
Thank you.
Proceed when you're ready.
Thank you, Your Honors, and may it please the court, Reynaldo Fuentes for the U.S. Department of Labor for respondent. This court should affirm the Administrative Review Board's dismissal of Mr. Garvey's complaint for a straightforward reason. Section 806 of the Sarbanes-Oxley Act does not apply to employees whose primary or principal place of employment is on foreign soil. The Supreme Court has repeatedly held that absent a clear affirmative statement from Congress, courts are to presume that federal statutes do not apply extraterritorially. Here, Section 806 does not contain such a clear affirmative statement.
Why isn't the definition of listing companies that includes foreign companies that list on U.S. exchanges enough?
Yes, Your Honor. We do understand that the coverage extends to some foreign employees under both Section 12 and Section 15D, as Mr. Garvey has alleged. But what we're concerned with is the geographic reach of those statutes, not necessarily the companies that are covered under that statute. We also could contemplate a scenario where Congress considered the foreign companies to ensure that they are covered under the anti-retaliation statute if they operate within the domestic bounds of the United States. And so that's why it goes to that first step, the Morrison first step analysis, which is there a clear, unmistakable statement from Congress that the statute is meant to apply extraterritorially? And here there is not, because the text and the structure and the legislative history of Section 806 indicate that Congress was not concerned necessarily with the international conduct and the retaliation well, not necessarily the retaliation, the international conduct as it relates to Section 806.
Well, the counter argument clearly is that what Congress was concerned about was the integrity of US stock exchanges. And it would seem to blow a big hole in the safety net that Sarbanes-Oxley erects to say, well, you know, if you're employing people overseas, and under your reading, you know, they're sitting overseas, but they're actually reporting directly to US managers. They're making decisions that affect the value and the integrity of stocks that are traded on US exchanges. And although we want to encourage employees throughout publicly traded companies to speak up and they see something unlawful, we don't want foreign employees who are located overseas to speak up. It seems to me that creates incentives for companies to move their employees overseas and do whatever hanky-panky the Sarbanes-Oxley provision was trying to put a stop to.
You started, the government's position would not be that this creates a hole that eviscerates the protections that Sarbanes-Oxley was enacted to remedy. We do recognize, and we agree with Mr. Garvey, that the meta purpose, the broader purpose of Sarbanes-Oxley is to perform a noble goal, which is to ensure that we have a regulated securities market that is safe for all investors.
And is it your position that 806 obligations apply? It's just the individual employee's remedy doesn't apply?
If the employees are based within the United States, then yes, or the domestic territory of the United States, then yes, those protections necessarily would apply because Congress wrote the statute to apply to the retaliation of employees, but did not provide extraterritorial enforcement. And Judge Pillard, to go back to
you just said did not provide extraterritorial enforcement. And my question was, is it only enforcement that's not available, but is the obligation on those issuers that they can't retaliate even overseas? Department of Labor won't go after them, but they are legally obligated by US law not to retaliate against those whistleblowers, or is that not your position?
Correct. The retaliation provisions, yes, do not extend to those companies necessarily under 806 to the employees that are engaged and where their primary or principal place of employment is abroad. But that doesn't stop international enforcement entirely. And that goes actually to a question that helps illuminate Section 806 entirely. When Section 806 was amended after the Morrison decision, Congress gave extraterritorial enforcement jurisdiction to the SEC to perform the types of international investigations that, as Your Honor, Judge Pillard mentioned, the DOL is not in a position necessarily to investigate. At the same time, they amended Section 806 and did not give it explicit extraterritorial reach. And so we can surmise from that exchange and from the way that the legislation was drafted initially that there is not extraterritorial reach. And so that is one of the facts that confirms Congress's intent.
So can you be more concrete? You say that there is international enforcement. What are you citing, chapter and verse?
Oh, the SEC, and forgive me, I don't have the statutory citation. The SEC has the provisions of the Dodd-Frank Act to perform international enforcement of some securities laws violations. And here, they may not be able to reach the type of retaliation claims that perhaps a whistleblower might be able to identify, but absent a clear expression from Congress that Section 806 should apply to employees whose primary or principal place of employment is abroad, we would be violating that presumption, and we want a clear statement from Congress. And
in terms of the locus of whether it's domestic retaliation or foreign retaliation, the place where the person is employed seems to me not a very persuasive test. So under your test, if Morgan Stanley New York employs people and says, you know, having learned from remote work during the pandemic, you can be anywhere in the world you want to be, but you report to us.
Yeah.
If the person is in Hong Kong, it's your position where they sit in a chair at a desk in Hong Kong, not covered.
Well, my first response, just to that answer, was that the ARB is not defined precisely what primary or principal place of employment would necessarily mean in every circumstance. And they recognize there could be factual scenarios in the future that present more complicated questions. But
like
here,
what?
For example, an employee who may be remote or employee who is on detail, somebody whose primary or principal place of employment could be in the United States, but they are only abroad. Why was Mr.
Garvey not effectively on detail? He said that he reported to people in New York.
Yes, and to the question of reporting, absolutely. We have ARB decisions in Who, the First Circuit in Carnero, the Supreme Court in Cayobel, recognizing that there can be domestic connections, including corporate decision-making, that could flow down and affect necessarily how the employment relationship is being governed, but they're not necessarily dispositive of the question around extraterritorial reach.
Corporate decisions, that's a much more general, making policy decisions that, tangentially affect the employee. But I take Mr. Garvey to be saying, I was working for the New York folks directly.
Well, in this circumstance, Mr. Garvey was employed for the Asian subsidiary of Morgan Stanley, worked primarily in Hong Kong, had an employment agreement that was governed by the laws of Hong Kong. And in fact, we want to avoid these types of foreign conflicts in the future. That's what animates the presumptions concerned. But here, Mr. Garvey's connections very similar to Carnero, the First Circuit decision that was decided before the Morrison decision, which actually indicated that there was corporate decision-making, decision makers sitting in the United States who might have made a decision to retaliate or initiated that system. And there was no extraterritorial reach for Section 806. And I see that I'm out of my time, but if your honors have any further questions, I'm happy to answer.
What's your best response to the description in Mr. Garvey's brief, Judge Levin in Walters, saying Section 806 does not protect employees for the sake of improving labor standards or conditions. Whistleblowers act on a voluntary basis. If they remain silent, their jobs are not in jeopardy. They can get along if they go along. The primary goal of Section 806 is not labor protection. It's to encourage employees to voluntarily take action that Congress thought was in the public interest. It's about protecting the stock market from fraud.
It's just the government doesn't disagree that a whistleblower's complaint and engagement in protected activity might somehow produce the results that Sarbanes-Oxley as a whole, its meta purpose might work.
It's not incidental, it might somehow produce. We're going to keep your job safe, and because you're a happy employee, you might, tell someone if something goes wrong. No, the whole point of it is tell us. Because the market depends on it, we live through Enron.
Absolutely. And the legislative history indicates that Congress was concerned with domestic whistleblowing, that there was evidence in the legislative record that there was a patchwork of whistleblower protections for domestic employees that Congress sought to remedy through Section 806 by creating a floor. Some states had stricter laws, some had none whistleblower protections. And so that's what animated congressional concern. And Congress had two bites of the apple, both when they enacted Sarbanes-Oxley and when they amended Section 806 to provide express extraterritorial reach. And they failed to do so. And I think that is a telling example of why this would not reach.
Colleagues, questions? Greg Rogers? All right. Hear from Mr. Connelly.
Thank you, Your Honor.
Thank you. Good morning, Mr. Connelly. You may proceed.
May it please the court. The ARB and the First and Second Circuits are right to hold that Section 806 does not extend to employment outside the United States. And I think here it's really critical to recognize Section 806 as a statute that has implications for employment in foreign countries, because the Supreme Court has said in a series of cases dating back to Foley's brothers in 1949 and Aramco again in 1991, but this is a setting where the possibility for international friction is very high. And when you add the private right of action that's in Section 806B, that only increases. And so I think the ARB and the courts have latched on to that quality of Section 806 in characterizing its focus as being about the terms and conditions of employment and adverse personnel action, rather than the Sarbanes-Oxley Act broader purpose of protecting the integrity of the markets, because Congress has at its disposal a set of tools to calibrate the right amount of interference with employment relationships abroad if it thinks that for its policy objectives, it's appropriate to do so. So I just want to point out a couple examples where Congress has done exactly that. And most notably, I think Title VII, after Aramco held that no foreign employment was covered under Title VII. Congress came back and didn't say, yes, it all is, or didn't say that all U.S. employer subsidiaries are covered. It said that U.S. citizens, with respect to employment in foreign country, are covered. And I think that that's an important limitation, and the kind of limitation that Congress can draw when it's cognizant of the possibility of international discord.
Is the same conduct, if it reached the level of criminal intent, reachable under Sarbanes-Oxley? In other words, retaliating against someone who's trying to come forward to expose fraud. My impression was that there is extraterritorial criminal jurisdiction.
For whistleblowing in particular, Your Honor, I'm not sure about that. There are, as Mr. Fuentes pointed out, amendments in 2010 through Dodd-Frank to increase the SEC's power to go after fraud overseas. I'm not sure. Usually, whistleblower actions like this are at the civil level, and there are others as well. There's one actually in Dodd-Frank. The Second Circuit has construed it as not having extraterritorial reach either. But I'm not aware of a criminal version of this particular statute. But I do think it's important not to lose sight of that private right of action. And I think when you're looking at the focus under Step 2 of Morrison, the Supreme Court's discussion in RJR Nabisco, I think, is very instructive in going by subdivision, subsection by subsection through RICO to look at the focus. And then at Western Gecko as well, they look not only at the damages provision, but also the infringement provision to find out the focus at issue in that case.
About whether this even raises a overseas application at all. Why? Sounds from the allegations like the Department of Labor could just investigate Morgan Stanley in New York.
I don't think that's true, Your Honor, and I think that underlying facts here about the protected activity, the alleged protected activity, illustrate the difficulties with litigating this kind of case, because a lot, if it went to the merits, let's say, in front of the agency, a lot will turn on the nature of the report and whether Morgan Stanley took it seriously or whether it decided to sweep it under the rug and retaliate against Mr. Garvey. We obviously don't think that that's what the facts would show, but the underlying events here concern investments in a power plant in India and investments in China. These are very complicated international transactions that would implicate the merits of the claim to see whether there's a causal connection between the protected activity and the alleged retaliation. And so I think that the issues get very complicated very quickly, and that I think explains why the possibility for international friction is not just at the level of the employment relationship, but also investigating the underlying protected activity.
I'm not sure I entirely follow that in this case.
I'm not following that at all because it's complicated. Suppose he was sitting in the U.S. and there's no doubt it's not extraterritorial. He's here. He's making the same kinds of claims. You're going to come back and say, well, some of them are complicated, involve international companies?
No, Your Honor, I'm sorry. I didn't mean to suggest that. Obviously, that's an easier case with respect to the regulation of the employment relationship, because that he wouldn't have a contract governed by Hong Kong law as he does here. I'm just saying that I don't want to give the impression that that the international character of the underlying events here are only superficial. They actually, he had a portfolio involving Asian Pacific legal issues, and he said, JA 296, that he didn't, Morgan Stanley did not rely on him for the delivery of any U.S. law advice. So I just wanted to didn't want the court to have the impression that this case is really about U.S. law 100%.
But what I'm taking from your answer is that if it happened that Mr. Garvey were doing the same work and actually sitting in the offices in New York, that somehow the Department of Labor couldn't feasibly do, consistent with international comedy, do an investigation, but I gather that it would be required to.
No, I think that's because the focus of Section 806 is on the employment action itself. The Department of Labor would not be investigating the underlying alleged fraud. That would be under the SEC's purview, if anything. So that I actually think that this helps support our interpretation of the focus of Section 806.
But because the Department of Labor's standard just looks to where he sits, it didn't inquire whether the retaliation alleged here was actually emanating from New York, taking place in New York, which some of this record evidence suggests, and Mr. Garvey claims is the case.
Well, I think in any of these cases, where the employee sits will be part of where the retaliation occurs, because you cannot have.
But that's what they limit their inquiry to that, and that seems wrong, even under your analysis. It just seems clunky and narrow and not really indicative of the question that extraterritoriality or not requires us to ask.
I don't think so, Your Honor. And I mean, remember that Mr. Garvey is alleging primarily a constructive discharge claim. So he resigned from Hong Kong. And so the alleged retaliation, if any, occurred in Hong Kong, not in the United States. And many of these cases, the Hu case, the Ulrich and Asadi case, even some extent the Carnero case, involve levels of oversight in the United States, even though the employee was located abroad. And all of those cases draw the same line that we're advocating for here.
In your mind, what's the most telling consideration to show that this is extraterritorial?
Take the location of the work site, which is where the alleged adverse effect on terms and conditions of employment was felt, and it is the most important consideration.
Thank you.
Thank you, Your Honor.
Did Mr. Garvey have any remaining time? All right, Mr. Garvey, we will give you 2 minutes for rebuttal.
Thank you, Your Honors. I'd just like to quickly address a couple of the points that my friends have raised. The possibility of foreign friction, Your Honors, I think is a little bit of a red herring here. I'm not seeking reinstatement, and I believe the court has ample flexibility in what relief to award, and so I don't believe that would be an impediment to hearing this case and accepting jurisdiction. I'd like to point out, too, that the Carnero decision, Your Honor, was ultimately rendered on the basis that there was, in fact, no protected activity under the statute because the concerns that Mr. Carnero raised were, in fact, about violations of the laws of Brazil and potentially Argentina, and not U.S. laws. I raised here concerns directly about U.S. law and domestic fraud, which is precisely the interest, I would argue, that this statute serves to protect. And finally, Your Honor, I would just address the point that the statute itself, 2010, when Congress amended the Sarbanes-Oxley Act in 2010, I believe that amendment, it introduced language which said that it clarified what had become, what was unclear as a result of Carnero. Are subsidiaries included or not? The formulation that Congress used very specifically for the second time running extends to foreign companies. Formulation, Your Honors, is that it includes a subsidiary or affiliates whose financial information is included in the consolidated financial statements of the issuer. That formulation is a technical formulation, does not respect boundaries, Your Honors. It does not respect national boundaries.
But that doesn't reach all employees who are working overseas. It reaches all employees who are at subsidiaries that fit that definition, that's all.
Well, Your Honor, the Supreme Court's case of Lawson versus FMR, which also interpreted the language of Section 806, concluded that when the statute refers to a covered entity, it refers to that covered entity, it imposes an obligation on that covered entity not to retaliate against its own employees.
I mean, that's a very strange way for Congress to amend the statute to get the result that you're now urging. Because all you have to do is say extraterritoriality is not a limitation here in discussion. To do it by saying these companies who are registered, certain subsidiaries, employees in that situation will have protection, and that's it. That's a real stretch. I mean, I don't know how to write that.
I hear what you're saying, Your Honor, but to that point, I think again, it would only be emphasizing, reinforcing what was already the case, the precise language of Section 806, the coverage of companies covered with a class, the coverage of those.
Do you think the statute facially?
I think facially, Your Honor.
That isn't the way I read your argument initially. You seem to accept the problem of extraterritoriality, and then you were working your way through in the brief to see if you could find some openings here or there. But the assumption that you have the extraterritorial bar and that you were in a bad situation there, but you were trying to find other ways out. You had connections to New York, et cetera. I'm really surprised to hear this argument now. That is not the argument I got from your brief.
Your Honor, I would disagree. I believe that the language, frankly, is unmistakably extends extraterritorial. I agree the statute unhelpfully doesn't use the language or the words foreign or extraterritorial. But I don't believe it's necessary where the implication of...
Is there a presumption I'm supposed to follow as a judge?
Well, there's a presumption, the presumption against extraterritoriality, sure, Your Honor, but it is just a presumption. And that presumption is I think what we can all agree on is it doesn't operate as a limit on Congress's power to legislate. And where the text is clear, as I would suggest that the coverage of companies for the class of securities registered under Section 12 is abundantly clear. Those are creations of Congress itself.
I mean, was the 210 Amendment? The 210 Amendment, I think, just hurt you badly. Because if you're starting out with what you say, there's no extraterritorial bar. There was no reason for that later amendment. And then when you get the later amendment, it's limited to certain situations and employees in those limited situations. So I don't know how that helps you. I think that as soon as I saw that, I said, that really is a damning consideration here, because Congress could have easily said, if there's any confusion about extraterritoriality, we're getting it out. Any kind of ownership relationship at all, you're covered. That's not what they said. Right?
Congress was not as clear as perhaps it could have been, Your Honor. But I would argue that, again, the case law subsequent to Carnero, immediately before the passage of the Dodd-Frank Act in Section 929A, you have the case that Judge Pillard referred to, which is Walters versus Deutsche Bank, which is in 2009. It's an ALJ decision. It's not a board decision. But I think it signified pretty clearly at that time that the Department of Labor itself was leaning in the direction of the arguments that I'm presenting here this morning.
Thank you.
Thank you.
Judge Rogers, any questions?
Thank
you very much.
Nina, can you hear me? Sometimes can't hear you. Can you hear me? Can't tell what these are.
Case number 21-7109 et al. National ATM Council Inc. et al. Versus Visa Inc. et al. Appellants. Mr. Anderson for the MasterCard and Visa appellants. General issues and issues specific to the consumer classes. Mr. Eisenstein for the MasterCard and Visa appellants. Issues specific to the ATM operator class. Mr. Rubin for the ATM operator appellees. Mr. Cooper for the Macman appellees. Mr. Lobel for the Burt appellees.
Hey, Mr. Anderson.
Good morning, Judge. May it please the court. My name is Justin Anderson. I represent MasterCard in this appeal from the erroneous certification of 3 classes challenging non-discrimination rules applicable to surcharges at ATM. I will address the 2 consumer classes and arguments that pertain to all 3 classes. My colleague Matthew Eisenstein, who represents Visa, will address issues specific to the class of independent ATM operators. Your Honors, the class certification in these cases violates settled circuit precedent and must be reversed. In rail freight, this court held that Rule 23 commands a hard look at injury models plaintiffs put forward in the district court to satisfy their burden of proving predominance. That hard look did not happen here. In the district court, MasterCard and Visa showed that each plaintiff's model of injury contained false positives. They swept in class members who could not have been injured. But the district court did not scrutinize the evidence that we presented. The court considered uninjured class members to be irrelevant to the question of class certification and deferred the issue to the merits phase of the case. It held that plaintiffs had a burden to only show a reasonable or colorable model of injury. That was error. The district court's analysis is directly contrary to rail freight, which instructs that it is, quote, indisputably the role of the district court to scrutinize evidence before granting certification, even when doing so requires inquiry into the merits of the claim, end quote. Whether the injury model can establish class-wide injury and withstand that level of scrutiny is not just a merits question. It is a question for class certification.
But why shouldn't we understand on review for abuse of discretion that what the district court said was, I see general claims on the plaintiff's part that every class member was injured, and I see evidence sufficient to support that. I see defendants countering with a different way of analyzing the evidence that, by the way, is also a wholesale, approach to a subset of the class. I'm satisfied that that is a situation in which common issues predominate, and I'll make the final call, or the jury will make the final call as to which analysis ultimately on the merits they accept. But isn't the predominance inquiry a filter that's supposed to look at, are these wholesale questions?
That's exactly.
Or are these case-by-case questions? And I don't actually see evidence in this record that's not wholesale.
Your Honor, that's exactly the right question that the district court should have answered. It should have asked that question and addressed the question. Instead, it held the plaintiffs to the burden only of showing a model that was colorable or well accepted. What the district court should have answered is this question. Is there common evidence that in one fell swoop can show that all members of the class were injured? That question, Your Honor, cannot be satisfied by the models here. Now, the district court did not scrutinize the evidence that we put forward. However, we showed that using—
He said he did.
Your Honor, the district court said that he was applying a standard that held the plaintiffs to only show that the models were reasonable. He said that the Mackin class had put forward a, quote, colorable and well-accepted methodology. That the Burr class had put forward a well-accepted methodology, and this was not an adjudication on the merits. He said that the independent ATM operators put forward both a colorful methodology, and it referred to our contesting of the merits as a question for the merits. That's directly contrary to rail freight, where this court said that plausible is not enough, but workable is not enough. The district court needs to take a hard look at the models that are put forward and determine whether they can identify injury across the class. Because if you can't show class-wide injury at class certification, we will raise this point again at summary judgment, and we will argue that there are class members who lack standing. And there are tens of thousands or more, hundreds of thousands, potentially, in light of the facts that we've put in front of the district court. The district court was required to scrutinize and grapple with that evidence. The plaintiff's theory in these cases on the consumer side is that for every 1 cent reduction in net interchange that ATM operators receive, they increase surcharges on consumers by 1 cent. It's a one-to-one relationship. It's a simple model of injury. They say every class member was injured in that fashion. But we scrutinized the evidence in the case, and we found for one of the country's largest banks that it did not raise surcharges at all during the class period and during the time frame that their experts evaluated. What that means is any class member who withdrew cash from that ATM was uninjured, and at a trial, we, MasterCard and Visa, would have the right to introduce evidence as to each class member, whether they withdrew cash from that ATM or one of thousands of other ATMs that did not increase surcharges during the class period, to show they lack injury, lack standing in this case.
What the plaintiff said in response, though, was not, oh, yeah, let's do one-by-one trials, or nor even, oh, you're right, there are some who are uninjured. What they said was, you didn't go back, the surcharges were raised earlier, and you don't account for that. And so I guess and the district judge does say all three plaintiff groups have demonstrated that common evidence will predominate in proving each element of their claim. So you can pull out, infelicitous comments that he makes about plausible or reasonable. I guess for me, it would be helpful to know more concretely what standard you think does apply. This has been a contested question across the circuits. And I understand that courts should make findings, but should it say, I reject your evidence and I credit the plaintiff's evidence? I took it to be more what I thought we agreed to before, which is that it should look at the character of the dispute. Is it between wholesale and wholesale, or is it something that, some granularity that is inevitable?
Your Honor, this court has already spoken to that question twice in the rail freight cases.
Can you give me more help in that? I don't.
I can, Your Honor. Yeah. In rail freight 1, the issue was that plaintiffs were seeking to recover damages for wholesalers who had purchased on contracts that were set before the alleged antitrust violation began. And that's what prompted that case. How could those people have been injured if they had locked in rates before the challenged activity began? And to the extent the model swept in uninjured class members, it failed the question of predominance. And that was the basis for the initial decision. That is the same issue here. How can someone who withdrew cash from an ATM that did not increase the surcharge, either in response to the reduction at interchange, or for some of them at all, argue that they've been injured? What is the basis for the injury when they did not pay the overcharge? It's the same question as
I want to be clear as to how far your argument goes. In other words, I'm clear as to your point about the district court's articulation of the legal standard he was to apply was erroneous as a matter of law. Now, you want us to reverse the district court's decision. My question is, the way your briefs, or not your briefs, but the way the arguments are made that you've presented as to, for instance, the largest ATM, maybe the class needs to be redefined in light of the appropriate standard to exclude those consumers. But it doesn't necessarily, or does it, foreclose the district court from, I'll just say in a sense, reaching the same result that a redefined class should be certified, as distinct from our deciding this case can never go forward under any definition of a class. And of course, if we reversed and remand, we wouldn't be doing that. But I just want to be clear, because your argument says that, you know, your clients presented this evidence showing there could be no injury as to a large number of potential class members. But I just want to be clear, does that mean even under the correct standard, or you're not deciding that now, but I want to be clear, when you said we should just reverse, I wondered whether that was what you were arguing. In fact, even though under abuse of discretion review, an error of law is an abuse of discretion. And so we would send it back and normally in cases, and let the district court apply the correct standard, but we wouldn't suggest no remand, thereby suggesting that there could be no other result on remand once the district court applies the correct legal standard.
Your Honor, we are asking for a reversal or a remand with instructions to decertify. And we recognize that that is not the course that the court would take ordinarily. But this case presents a unique scenario where it is a question of law about whether the district court applied the correct standard. He did not. If you apply the correct standard here, the undisputed facts show, because plaintiff's own experts admitted that there are ATMs that did surcharges in response to the reduction in net interchange.
I'm not contesting that argument that you make. I'm just asking, could not the district court, or do you say it would be impossible for the district court, even upon applying the correct standard, on remand to offer the plaintiffs an opportunity to redefine the class and then determine on the basis of that redefined class whether or not the plaintiffs had met their burden?
It would, Your Honor. Under the applicable standard, the plaintiffs have simply not given the district court the tools it would need to approve a class that winnows out uninjured class members. And that's why we referred the court to the Third Circuit precedents in Borgess, in Real Life USA, and the Eighth Circuit decision in Audit. In those cases where even if you remanded to the district court, remand would be futile because there is no ability, and the plaintiffs have come forward with no proposal for how they would winnow out the class members who withdrew cash from ATMs that did not surcharges in response to reduction in
that is not the way we typically deal with legal error and factual error. I mean, the Supreme Court has told us a long time ago the district court is relying on the incorrect statement of the law. You send it back and the district court's now got to apply what we tell. Correct statement of the law and then find the facts. We don't, I'm listening to you carefully. What you're asking us to do is make findings of fact. We have been told over and over again we don't do that.
And Your Honor, we're not asking you to make findings of fact. We are asking you to reverse on the undisputed record here. We are not contesting that plaintiffs' experts in their rebuttal reports found that there were certain ATMs where there was no statistically significant relationship between the reduction of net interchange and an increase in surcharge. They admitted there's no need for fact-finding. On their own experts' analysis, there are uninjured class members in this case. Plaintiffs have waived any right to argue that they're entitled to show that there's a winnowing mechanism that could filter them out. Each one of them, all three sets, have doubled down in their briefs saying every class member is injured. Every class member paid an inflated surcharge. They should be held to that.
I think what we're trying to get at is you're precluding the district court, and I just want to be sure you're making this argument as a matter of law, from saying to the plaintiffs, well, the models you've given me now are insufficient for many of the reasons your clients point out. I mean, they're experts, just hypothesize about things, et cetera. They don't point to hard data. But suppose the plaintiff said, well, we want to redefine the class. And I don't want to go too far here, but just assume they say, well, we accept the point that the largest ATM, there's no injury as to them, but there are these other people. Now it may be a much smaller class, but your argument seems to preclude that opportunity for the plaintiffs. And I gather from what your response to me is, well, they waived any argument. And I just wondered, in other words, you're saying they'd have to start all over again and file a new complaint.
Your Honor, that's right. This case has been pending for 10 years. Rail freight was decided in 2013. This is not a new legal standard. The plaintiffs are represented by able counsel and assisted by economists whose credentials are well accepted. They had every opportunity to argue that if there were uninjured class members, they had a model for winnowing them out. We had discovery is now closed. This case the record is closed on both expert discovery and fact discovery. For them now to go back to the district court and reopen that record and propose some fashion of winnowing out uninjured class members would be an unfair burden, unfairly prejudicial to the defendants who have lived with this case for the last 10 years.
Well, you had a time limit to file your petition for review. But I initially thought, well, why didn't you file a motion for reconsideration by the district court, making the legal arguments you've made? And in that situation, hypothetically, the district court might have said, oh, yes, I'm relying on this vitamins decision, but the circuit and the Supreme Court have abandoned that colorable approach. And now the standard is different. And so I'm going to apply that standard. And so I gather part of your argument was you pointed all this out to the district court, and nevertheless, it ruled as it did, applying the vitamins colorable standard, which was no longer the standard that applied.
That's right, Your Honor. And normally, if you file a motion for reconsideration, you have to tell the judge, here's the new thing we want you to consider. And we had put all of these arguments in front of the district court in our briefing. The question of predominance, the question of uninjured class members was not some side issue. This was the issue. This was the issue that we contested. There were other smaller issues, but this was the main issue that we contested class certification on with these classes. Your Honor, I had...
What is the standard that you think the district court should apply?
It should take the hard look that this court said is required in rail freight. The Supreme Court has called it a close look in Comcast, also a, quote, rigorous analysis, end quote, that's from Comcast. And in Walmart, the Supreme Court said the court must make findings. That's a quote, even if it, again, overlaps with the merits.
What of those things, I mean, how can we confidently say, reading the district court's opinion, that it didn't take a hard look, a close look, it make a rigorous analysis? And indeed, the district judge said, I find, and makes the findings. I mean, it's...
Your Honor, if that was sufficient, this court would be deprived of appellate review in any case, because every district judge could be counted on to put in the magic word.
We had rail freight, and we said, you know, there's some plaintiff acknowledges there the limitations and didn't have a comeback. And we said, okay, no class.
The rail freight was pre-Comcast. So the first rail freight decision was decided when the district court did not have the benefit of the Comcast decision. So on appeal, the panel acknowledged that the district court was applying old law. And so in that case, it cannot be the case that this court only has the ability to review district court decisions where the district court acknowledges that it is not doing what the standard requires. It can't be the case that...
So it's, I mean, Comcast is a much clearer, different case, right? There were 4 different theories. The only one of them was deemed viable, but the plaintiffs or the district court continued to rely on a damages model that was predicated on all 4. We just don't have something like that. The way I read Comcast and the rail freight decisions, they're pointing to particular kinds of errors. You know, plaintiff acknowledged that there was, some 12+% of uninjured class members, didn't have a comeback on that. Barron's we just talked about. This, you haven't pointed that kind of defect here. It's really, we have this one take on the data. They have a different take. They're saying everybody's injured. District judge isn't saying they're right, but is saying they've come forward with that. And that's standard evidence. It's evidence that could be credited. Good enough.
Your Honor, the problem is that good enough for the district court is not good enough based on the standards the Supreme Court has announced and this court has
Which
announced
standard?
In Comcast and Walmart,
Hard
both
look.
rail freight decisions. The district court cannot just say good enough. It needs to take a hard look at the evidence, scrutinize evidence that's put forward by the defendants, and determine whether the models can withstand that scrutiny and show that common evidence will establish class-wide and is capable of establishing class-wide injury. That hard look did not happen here. And this court cannot defer to decisions that clearly apply the wrong standards simply because the court writes, I've considered the evidence and concluded X. That is clearly not sufficient to meet the hard look, rigorous standard that's required here. Otherwise, it would gut the standard. It would gut the precedent from this court in rail freight. It would gut Comcast and Walmart that this is not a class certification, it's not a perfunctory stage similar to a motion to dismiss. This is a case, this is a stage in the case where the district court must take a hard look and resolve disputes between the parties about whether the injury model that plaintiffs put forward is capable of showing class-wide injury. Here, plaintiffs came forward and said, everyone's injured because for every 1 cent, the net interchange goes down, surcharge goes up by 1 cent. We showed the district court that there are tens of thousands in the record plaintiffs swept in who withdrew cash from ATMs that never increased the surcharge in response to the decrease in net interchange. The judge needed to grapple with that. And if he had, Judge Rogers, he would have found that the evidence is indisputable. There are uninjured class members in this case. Judge, we are not asking for fact-finding. We are asking this court to apply the law to the undisputed facts in the case, which is that there are ATMs that did not increase surcharges in response to the reduction in net interchange.
Thank you. Morning, Mr. Eisenstein.
Good morning, Your Honors. May it please the court. I'm Matt Eisenstein. I'm going to address the independent operators case. I'm going to try to avoid repeating what Mr. Anderson said, but the district court's decision as to the independent operator case did not apply the right standard and should be vacated for the same reason as the consumer cases. Because these plaintiffs do not have common proof that they can use to establish injury to all class members as they define the class, their class. These plaintiffs say that their injury is that all class members paid an inflated acquirer fee. But we know from the record that many class members did not pay those fees directly to the network or indirectly, such as by receiving a portion of interchange revenue from which acquirer fees are deducted. Here's how we know that, and the key facts here as to this case really are undisputed. These plaintiffs concede that they took the definition of an ATM operator from a Visa rule. They say that at page 9 of their brief. They say that at page 10 of the brief. They say that in footnote 5 of their brief. Visa's definition of an ATM operator is very broad. It's designed to track entities that could have access to information at independent ATMs and therefore could present fraud or other risks to the network. We know that from JA 6808, which is a declaration from the head of Visa's ATM business. We know that from JA 7026, which is a document adopting the Visa rule. The documents make clear that the definition that they use, the Visa definition, which is the same as their class definition, has nothing to do with which entities pay acquirer fees directly or indirectly, has nothing to do with which entities manage cryptographic functions. It sweeps much broader because its purpose is to minimize risk of fraud. And the documents make clear that there's a range of entities, more than one entity per terminal, that can satisfy the definition of an ATM operator.
But the class definition is narrower. It explicitly excludes a lot of the entities that I think you say are muddying the waters, no?
That's incorrect, Your Honor, respectfully. It's the same, the definition is coextensive. They're the same. So, for example, a merchant that owns an ATM owns an ATM and that loads cash in the ATM. He's a class member. It's a ATM operator. We know that. There's an example at JA 6078. It is a form filled out by a merchant that meets the definition of ATM operator. We know from JA 6070, which are guidelines from an acquiring bank, that there can be more than one ATM operator per terminal. That's important because you could take an example of an ATM at a corner store here in DC. If the merchant owns that ATM, it can be the ATM operator. If there's a sales entity that deployed the ATM to the owner, it can be the ATM operator. If there's an entity that provides actual processing services, it can be an ATM operator. Sometimes those entities receive the net interchange or share in it. Other times they don't. But whether they receive net interchange or paid acquire fee, which is the injury they say exists, is irrelevant.
Where do we know that sometimes they receive net interchange and sometimes they don't?
Your Honor, we know that, and I apologize, I'm throwing a lot of cites at the court, but it's important because this is exactly what Judge Leon didn't do, which is scrutinize the evidence in the record of uninjured class members. So we know from JA 6108, and that's a class member in this case that's talking about merchants who own and load, have own and load arrangements. And it makes clear that sometimes they do pay acquirer, sometimes they do pay acquirer fees indirectly, these merchants, and other times they don't. He set out for the merchants that he deals with, it's 30% versus 70%.
My question was, I thought you had asserted that sometimes they receive net interchange and sometimes they don't. And now you're talking about whether they pay acquirer fees.
Right. I mean, it's they receive net interchange from which the acquirer fees are deducted. And as I understand it, that's the plaintiffs, ultimately what the plaintiffs say. What we're saying to you, Your Honors, is that there are ATM operators that do not receive net interchange at all.
So there's that testimony. Is there anything else?
Yes, there's testimony at 5460 and 5461, which is another example of merchants in these own and load circumstances that sometimes. So the question was in that circumstance, in most they load arrangements, the customer does not receive any interchange, and the answer is correct. And then there's another question: do any customers with they load arrangements pay network fees? And this is for this
customers here, meaning independent,
meaning yes, meaning ATM operator, meaning a class member, as they have defined class, which is the same as the definition of the Visa rule. Let me just, if I may.
I want to ask you a question, and I asked Visa counsel a question, but I need to be clear that you take the same position. If this court were to hold that the district court, in applying a colorable standard based on the vitamins decision in the district court, that was a clear error of law, given that this court and the Supreme Court have rejected that standard in determining the burden that the plaintiffs face. So hypothetically, just suppose we say that and we remand the case to the district court. And the plaintiffs say, well, in light of the remand, in light of this post-vitamins authority, we want to concede the point that, or with the district court to find that, we agree with the defendant's experts and what the record shows. But it doesn't show that there are no consumers or no operators who had to pay these fees. And that's what I need to be clear about. Why wouldn't on remand the district court be required to do the type of meticulous record review where you're citing all these pages in the joint appendix and make conclusions? And suppose where the class as originally proposed, involved millions. When the district court looks at the record closely and sees what's there, and that his colorable standard is no longer the standard that applies to models, he determines, well, under this more rigorous standard, I agree that the plaintiffs haven't met their burden as to some of the members of the defined class. And then the plaintiffs say, fine, we want to redefine the class in light of this new standard. And when I heard Visa counsel tell me, well, this case is 10 years old, it's just too late to give them another chance. Is that your position too?
Your Honor, it is my position, and there is a particular reason with respect to the ATM operators. For them, they cannot narrow their class definition to just refer to entities that pay acquirer fees directly or indirectly. They can't do that because their entire liability and causation theory is that these rules restrain ATM operators, class members, from setting surcharges at different levels based on the ATM network. If the class is limited to entities that paid acquirer fees directly or indirectly, or received net interchange indirectly or directly, it would exclude significant swaths of entities that are actually responsible for setting surcharges at the terminals. And this class needs to have those entities in, they need it for their theory of liability and their theory of causation, which is that these rules affect the ATM operator.
You've just done a beautiful job of articulating what I think Judge Leon found to be a sufficiently general theory of liability. If it's accepted, then although it may show up in the wash in different places for different independent ATM operators, if the plaintiff's theory is accepted, they are all harmed. They may, receive it in different ways, in different fractions, but it's out there in the market. This non-competitive price that imposes opportunity costs on businesses that would offer a cheaper service if they could. Why isn't that classic predominance?
Your Honor, that is exactly the issue that requires individualized inquiry, because we take a single ATM and we look at the entity that's responsible for setting the surcharges. We look at the entity, there may be a different entity that's getting the acquire fee. If they're different entities, if there are different reasons for changing surcharges, for example, at a casino where they just want to jack up surcharges and there's a different entity that's receiving the economics from the network, then it really does boil down to an individualized inquiry and the common evidence they have of injury, which is of the payment of acquirer fees, cannot be applied to the class as a whole, because We know there are uninjured class members. We know.
I don't follow that. If just because I'm willing to, take this as a loss leader because I want to bring people into my casino, it doesn't mean that it's not a piece of my financial equation that could be different, but for an anti-competitive rule.
What they need is common evidence to establish injury. And they have defined, they say all class members as they've defined it are injured by the payment of an inflated acquirer fee. And we know, based on this class definition, that there are entities that don't pay that acquirer fee at all. And so therefore, this common evidence they have can't be used for all of their
What's your
class
best
members.
example of the ones that don't pay? Like, can you explain in a way, if you're trying to make this theory make sense, not just, throwing up things that aren't explained. Can you affirmatively explain why it would be that there would be entities that don't pay acquirer fees?
I appreciate that, Your Honor. And I've cited a few examples from the record. You can think of, again, let's go back to our corner store. The ATM is rolled in to the corner store. The merchant has the discretion, the corner store itself, as an ATM operator, has discretion to set interchange, to set the surcharges at whatever level it wants. In this situation, just bear with me. Well, that's in the record. There are examples of merchants that have the ability to set surcharges. They have the discretion. They are ATM operators. They're also merchants. They have their own discretion
To set them below Visas and MasterCard.
To set them at the level they want, consistent with the rules at issue. So they can surcharge everybody $5. They can surcharge everybody $10 for taking out cash.
How about $2? How about $1?
Yes, they can. We're not talking about the operation of the rule. We're talking about here that there's a distinction, Your Honor, between the operation of the rule with respect to the entities that it restrains on the one hand, and the entities who these plaintiffs are claiming are harmed, which are the ATM operators that are actually paying the acquirer fee indirectly. They don't have to be the same. That's part of the problem here. And the record sites we provided, I think, illustrate that. I see I'm way over time. I will just emphasize that in Rail Freight 2, this court has made clear that it's improper to defer questions about the number and nature of individualized inquiries that might be necessary to establish liability. That's exactly what happened below.
And do you have a standard that you think we should adopt other than hard look, rigorous?
All I have, Your Honor, is the language from Rail Freight 2. And I believe that language ought to apply here. I just read it. And I agree with my colleague, Justin Anderson, on that issue.
Thank you.
Thank you very much, Your Honors.
And I think you're not seeking any rebuttal, but Mr. Anderson is.
Thank you.
All right, and I believe we hear next from Mr. Rubin.
Good morning, Your Honor. May it please the court, I'm Jonathan Rubin with Mogan Rubin LLP on behalf of the ATM operator plaintiffs. My comments today will be addressed solely to the case brought by the ATM operator plaintiffs. I believe the issues involved with the operators are substantially different, as is the nature of the class and the nature of the claim. So restricting our attention to the ATM operator plaintiffs, I think it's clear, it's been said before, that the standard of review is abuse of discretion or clear legal error. This is a very deferential standard. And we don't believe that, and in addition, the DC Circuit case law calls out in several cases that it's the district court that is uniquely well situated We don't believe the defendants have met the standards and have established that there is any abuse of discretion or any legal error. There is no indication in the briefs or elsewhere that the court failed to consider anything. Either the defendants...
Mr. Rubin, is it always true that the acquiring bank remits net interchange to the ATM operator?
Thank you for the question, Your Honor. There's a great deal of confusion, some of which was just presented to this court. There are certain layers that exist in the industry that exist because the networks do not permit non-financial institutions to be members. Accordingly, there is the network at the top layer. There is a layer of financial institutions thereunder, and under financial institutions, there are non-financial.
One of the basic pieces of advice that I give to people arguing is that when somebody asks you a question, I can't even absorb what you're saying unless you tell me before you get going into the details, yes or no. Is it always true that the acquiring bank remits net interchange to an independent ATM operator?
Your Honor, the word remit suggests that there is a payment from the acquiring bank to the network. We do not believe the acquiring bank touches any of the money. The acquiring bank is lending their credentials as a member of the network to the ISO, and the acquiring bank is not the correct term here. It's incorrectly stated in appellant's brief. The correct term is sponsoring bank. There are 4 or 5 sponsoring banks that sponsor independent ATMs. We have testimony in the record from the processors who specialize in processing ATM transactions that the acquiring banks, the sponsoring banks do not touch the money. The money is paid by the processors who are in the layer between the networks and the functional entities. What happens is that Mr. Eisenstein...
Do the processors always, do the ATM operators get that?
What happens is the ATM operators on a per transaction basis are entitled to a payment of interchange. Sometimes it's called reverse interchange because it's different from the point of sale interchange. But that is an additional revenue stream on a per transaction basis that is paid by the issuing bank to the ATM operator through the processor.
So you're saying the ATM operators do get this? They get
interchange on every transaction, and that interchange, when the processor passes it to the ATM operator, they deduct the network fee and send it to the network in a mass for all of their ATM operator customers.
And is there a place in the record you would point me to for that point?
I would point you to I don't have the pin site for it, but it's the testimony of Paul Willingham, who is a functionary with Switch Commerce, which is a processor that specializes in ATM processing. I think a crucial point I need to make at this point, however, is that every ATM operator is entitled to receive interchange. It gets the interchange, and what it does with it is what Mr. Eisenstein was talking about. Downstream from the ATM operator are other parties, in particular, the location owner. The location owner is the customer of the ATM operator. There are arrangements that the ATM operator says, as part of payment of rent, we will give you a portion or all of our interchange revenue. Mr. Eisenstein has told this court that because of that, the ATM operator does not pay acquiring fees. This is plainly ridiculous. It is as if I were to say that because my employer deducts my taxes from my paycheck and pays me a net salary, I don't pay taxes. My employer pays the tax. It is clear from the report of Dr. McAndrews, who was a head of research for the New York Fed for 6 years, that the economic incidence of ATM acquirer fees falls on the ATM operator, regardless of what they do downstream with their customers. Whether or not they give their interchange away does not affect whether they have suffered the incidence of the acquirer fee. The
I urge the court to take a look at the announcement in 2005 where Visa introduced the term ATM operator. The class definition is not a wholesale adoption of Visa's terminology, but we have taken their approach to defining ATM operator as the entity in the environment that does certain things. One of the things they do is give the instructions to the processor regarding the level of the surcharge, who is to receive the interchange, who is to receive the surcharge, to handle the encryption keys, and to otherwise operate the ATM. I direct the court to JA 6897, where one of the founders of Processor Switch Commerce explains what it is that an ATM operator does that no other party can do, which means encryption keys, communicating regarding the level of the surcharge and who gets the interchange. These are things that a merchant cannot do. In 2005, when Visa defined an ATM operator, they put a footnote in their rules. And it said quite clearly that premises owners are not ATM operators. Even if the merchant loads the cash into the machine, they are not an ATM operator. Even if they receive interchange, they're not the ATM operator. They are never permitted to change the surcharge or direct the distribution of funds, that is, or handle encryption keys. Those are the roles of only the ATM operator. Finally, I understand my time is short, but I need to make this point, and that is that if in fact there was variation in who pays the acquirer fee, where is the evidence of that? Where is the memo that says, oh, in this particular case, somebody else will pay the acquirer fee? Or the network letter that says, oh, we didn't get the acquirer fee from whoever you are supposed to pay it. The reason there is no evidence of this is because there is a custom and practice in this industry that has been around for almost 30 years, and that is that the deployer of the ATM is responsible for the acquirer fee. That is why, without a shadow of the doubt, and after a rigorous analysis, which, by the way, was the standard since 1982, with a Supreme Court case by the name of Falcon, I think General Telephone versus Falcon. That's where rigorous analysis comes. Judge Leon is fully familiar with this standard. There is really zero evidence on the part of the defendants that shows that there is anything other than the practice and custom that the ATM operator deployer pays every penny of the acquirer fee, and we stand strongly by our contention that every ATM operator member of the class pays the acquirer fee.
Judge Rogers, did you have any further questions from Mr. Rubin? All right, thank you, Mr. Rubin. I think we'll hear next from Mr. Cooper.
Thank you, Your Honor. May it please the court, David Cooper on behalf of the Mackman class. If the defendants make only one very narrow argument against certification of the Mackman class. They say that all the evidence of class-wide injury does not suffice because our expert used Wells Fargo data in his injury model, and that data is supposedly not representative of the class. But in looking at this issue, it's crucial to note that no one uses complete data for all the transactions because that data doesn't exist. So the experts had a choice. Do you use the complete data for one bank, Wells Fargo, or do you use incomplete data for the other banks, limited to transactions over one particular network? Each expert explained why they made their choice, why our expert chose to do the complete data for one, why their expert chose to do incomplete data for the others. And the question here is whether the district court and this court should resolve this choice of data battle of the experts on class certification.
Let me just tell you, and there one more.
Yes.
My review of the record and thinking about what the district court did and what both sides are arguing is, and I can't pinpoint it precisely, One problem that leaps out for me is it does not appear to be common evidence that sustains class-wide injuries, and that there are a number of persons in the class or classes for whom there is no indication that there is injury. It just seemed fairly straightforward to me. And I don't know how, in light of the existing law, that can stand.
So there is.
You're not doubting that because my understanding was that your argument was, well, we can whittle away, we can work that out later. And I thought the district court was saying, you can work that out later. But there isn't any doubt under the models that are being pressed, there wasn't any doubt in my mind. In the models that are being pressed, there are large numbers of members in the alleged classes that are not injured. There's nothing to indicate injury.
So no, our position is not that you should be whittling those out. Our position is that there are no uninjured class members.
Every single member in all of the stated classes has been shown to be injured.
In the Mackman class, we're not representing anything with respect. I'm not representing anything with respect to the other classes. I'm saying in the Mackman class, there are no uninjured class members. And there are two competing models. One, which shows that net interchange increases surcharges. Their model shows that for some limited number of banks, there's the statistics are inadequate to make a determination. But the point is that their model uses incomplete data. Our expert explained that if this court looks at nothing else in this very large joint appendix, we'd ask this court to look very closely at the section beginning at JA 8366. Our expert explains in great detail why their model, limiting only to the transactions over the Visa network, is the wrong way to look at this. And that there are no uninjured class members because this idea that they exist only happens because you're looking at a very limited data set, looking at only a particular kind of transaction. So the question is, what do you do when you have competing models? They try to shoehorn it into rail freight by saying it's undisputed. It's undisputed. It is disputed. Our model does not show uninjured class members. Their model supposedly shows uninjured class members. And the question is, whose data and whose methodology is correct? That's a classic Daubert question. And they could have raised that in a Daubert motion. They chose not to.
But why aren't they saying, yeah, your data is, at least our data shows your data not to be representative, because we look at these Visa transactions and what your expert is asserting with respect to the Wells Fargo data appears not to hold with respect to non-Wells Fargo transactions, i.e. these Visa transactions. And your response to that is?
Our response to that is when you look at only the Visa transaction, it distorts the entire model. In other words, you don't get a true answer for Visa transactions. You just get a very, questionable answer for all transactions. And the reason why, if this court looks at the charts on pages JA 8377 and 8379, it sort of explains why, which is that the net interchange for the different networks moved at different times. And the mix of what networks bank ATMs were using changed at different times. And as a result, if you're only looking at transactions over the Visa network, you're distorting the entire model because you're looking at how surcharges change generally, but you're looking at how net interchange changed only for one network, which isn't necessarily representative of the mix of networks and the mix of net interchange fees that the banks received and the banks presumably would be reacting to in raising surcharges. And I think it's also important to note that it's simply false when they say that there are banks that didn't raise surcharges at all during the class period. And I'd call this court's attention to JA 8398 to 99, where they say 13 banks didn't raise surcharges. That's because they start in 2010. Our class starts in 2007. And to be clear, we say that the NDRs affected net interchange long before that. And so the prices were, the surcharges were high even at the start of the class period.
So Citibank set it high earlier, is your view. Do I have the facts right? Citibank?
Yes.
You're saying it, that they set it high, they didn't have to raise it in response, but isn't that inconsistent with your theory, which is that it's in response to diminution of net interchange that the surcharges are raised?
So, yeah, it's not inconsistent because net interchange did go down even before the class period. In fact, substantially before the class period. So when they raised surcharges in 2007 to 2008, that was in response to a reduction of net interchange. So these things happen at different points in time, and it's important to keep that in mind. I think the other important point to keep in mind is that even with their model, if you apply it to the entire class period, 95 out of the 100 banks showed this, of the top 100 banks, showed this relationship between net interchange and surcharge. And so for those, there's essentially no dispute that we have common evidence of class-wide injury. And so the question is, what about those other 5? And what our argument is simply that if you're trying to extrapolate, because we don't have complete data for those other 5, if you're trying to figure out, based on the data we have, does it make more sense to extrapolate from Wells Fargo and from those 95, or to think that 5 banks would be such outliers that in response to a lower net interchange, and in response to the other 95 banks keeping surcharges low because they were getting more net interchange in this but-for world without the anti-competitive conduct, those 5 banks would do nothing. They would keep their surcharges extremely high and be completely anti-competitive. And our expert explained why in this market that makes absolutely no sense at all. And while this court, obviously we're not asking to decide who's making more sense, the question is, I see my time's up, but if I could continue.
Yeah.
The question is, what are you deciding? Because it can't be that the decision is whose expert is right and whose expert is wrong. That can't be the question on class certification. And I know that, the defendant's counsel says we'll take a hard look. But the question is a hard look at what? So you're taking your hard look and what are you deciding?
You're taking a hard look at the evidence that's being offered to determine whether most of the members of the class are injured.
So I don't think...
Isn't that what we're supposed to be doing? Is that what the district court judge is supposed to be doing? Are you stating a theory where what you're suggesting as the model for weighing the evidence would exclude a number of the class members? That's not good. That would fail the hard look test, right?
No, respectfully, we're not saying that you should, we're saying that what you should look at is whether the questions can be answered on a class-wide basis, not whether or not the questions will be answered in our favor. That's what Amgen says. So the question is not whether we did prove that in fact all
but if the other side says, and I'm not saying anything about this case, the other side says 20%, 30% of the people in their proposed class under their model cannot possibly be shown to be injured. That fails hard look, doesn't it?
Well, if it's cannot possibly, that's rail freight 1. Yes, cannot possibly. Right. And we're clearly not within.
If they say cannot possibly?
No. So rail freight 1 says detects injury where none could exist. In other words, if not whether they say or we say, but whether in fact if injury could not exist, yes, we agree that would fail. Or in rail freight 2, if they're saying our own model shows that they're uninjured class members and there is, quote, no common proof, that would fail too. But when you have a dispute between the experts and the totality of the evidence on both sides of whether there are uninjured class members, the question is, and Tyson explains this very well, is that can that dispute itself be resolved on a class-wide basis? And that's why Tyson said a dispute over whether data is sufficiently representative is one that can be decided on a class-wide basis and therefore does not preclude class certification. So you're certainly taking a hard look, you're taking a rigorous analysis of what the evidence is and whether or not the trial, if it goes forward, could be done on a class-wide basis. What you're not doing is deciding who's right or wrong and effectively just sort of taking the merits away from the jury just because it's a class-wide case. And if I could just close by saying one thing in response to Judge Rogers' question about remand.
Could I just ask you, you're reading Tyson's to say what?
Sure. So I think there are 2 critical pieces of language in Tyson. The first is that, quote, statistically inadequate, whether data is statistically inadequate or based on implausible assumptions, did not raise a challenge to the and is insufficient. If they don't raise a challenge on data to statistical inadequacy, then that's not a class-wide issue. And then the second piece of language, and the court explains why, is that because whether or not it was unrepresentative or inaccurate is itself common to the claims made by all class members. So that's ultimately the question. Can we decide this class-wide? Not who's right about it, but can we decide it class-wide? And here we clearly can. They're not producing a ton of individual evidence that would force us to not resolve this in a class-wide matter. And we're here with class-wide evidence talking about whose expert is right. And so that can be done on Daubert, that can be done on summary judgment, but it should not be done on class certification, and certainly not under a standard where you're saying just, okay, we're going to pick which expert chose the right data. Because this is not a case where our expert has admitted at all, where our model admits at all that they're uninjured class members. It's where their model, using incomplete data, shows for a small subset that we can't tell because the data is so inadequate that we can't reach a statistical conclusion.
So if at a later time, and I'm not sure when it would be, the district judge looks further, hears from these experts, at trial, I guess, and Visa and MasterCard move to have the class decertified. And the judge says, look, I'm crediting their data, not yours. The district judge could decertify the class. Would have to, if he credited their approach.
Well,
You might have an appellate issue, but he would have to decertify the class?
If it were on a summary, if, for example, on summary, I mean, the question is at what stage is the judge doing that, right? But if it were, for example, Daubert, let's say they made a Daubert motion, even though they could have made it before, but let's say hypothetically they could raise one later, they make it, or the judge says, no, this is unreliable, I have to throw it out. Yes, the judge could decertify the class, and Rule 23 accounts for that. Rule 23 says the trial judge does have a continuing obligation to look at the class and to see whether or not the class should remain certified. So we have no problem with the district judge having the authority and the discretion to look at this going forward. The only problem we have is with this court, or even on remand the district court, deciding at this stage of the proceedings which expert is right and which expert is wrong under some nebulous standard of hard look, but we're not going to say sort of what the actual reliability or plausibility standard is.
So the district judge is supposed to find predominance, but not make fact findings about which expert to credit?
Yes, I think that's correct. I think that the question is, if you look at the expert reports, can the issues, the dispute between the experts and more generally whether or not, all class members were injured, be decided on a class-wide basis? If the nature of the reports is such that it cannot be decided on a class-wide basis, then you would fail predominance.
And what's your short answer to why the Wells Fargo data is representative?
Sure. So I think there are a couple of points in that. First, it is the complete data. There's no dispute that that is, in fact, the best data to use because it includes all of the transactions. So that's why we use it. Now, why is Wells Fargo representative? Our expert explained in great detail why. It's about the nature of this market, which is that it's a commoditized product, ATMs, an extremely competitive market in terms of the surcharges. And if you look at the market historically and do an empirical analysis of it, that the banks do move together. That is to say, you don't have these outliers where a bank just chooses to be completely non-competitive. So Wells Fargo is one of the largest banks in the country. It exhibited this relationship. Even using their own incomplete data, 95 out of 100 exhibited this relationship. It is more than a reasonable conclusion from all of that and from their, frankly, a ton of documentary evidence showing that this is in fact actually what happened. It's a far more than reasonable conclusion to say that, yes, there is this relationship and this relationship exists for all of the banks. And so that's what our experts said. And the district court is well within its discretion in accepting that conclusion.
Right. Questions from my colleagues?
No.
Right. And we will now hear, thank you, Mr. Cooper. We'll now hear from Mr. Is it Lovell or Lavelle?
Lovell.
Lovell for the Burke plaintiffs.
I'd like to start to try to address Judge Edwards' questions. First, this legal standard for antitrust injury is whether the prices paid in the actual world are higher than what the prices would have been in the but-for world, so that prices can go down in the actual world. In the conspiratorial environment, prices can go down. In footnote 2 of our brief, we cite the Lotrin, LCD, lots of cases which haven't been contested, that in high-tech cases, in-rate ebooks, et cetera, real-world prices go down, but those prices are higher than they would have been in the absence of the conspiracy. So the trick is to look at the but-for world for the antitrust injury. Now, so their whole standard, this thing, is a false construct. Prices had to go up during the conspiracy period. Let's now, if I just address the differences between this case, you have to go to the facts to some extent. The differences between this case and rail freight 2. In this case, the price fixing rules existed for every transaction, every day, every year for 30 years from the mid-1990s until today. And there was no chance for a competitive market to develop. In rail freight, there was a before period where there was no conspiracy. There was a during period where an alleged conspiracy to fix the fuel surcharge started up. The plaintiff's model, using the before period or a clean period did a regression, and they came in and they showed that 12.7% of the people had a gain, had negative damages. And that was it. There's a lot of, the real freight too has a lot of interesting comments in it. But what it comes down to is that the Judge Freeman was within his discretion to find that 12.7% is way too much, and it's uncontested, and there's no way to get around your own model, what it shows. Here, and here there is no before period. We can't run a regression. We're being held to a false standard from a different case where they could have a before period and do a regression. In our case, all the transactions have been conducted in a conspiratorial environment, and you can't do a proper regression in that environment. And then now turn to the admissions that were before Judge Leon by defendant's expert, Dr. Hubbard. He admitted that his study that purported to show that a small minority of the ATMs did not raise their surcharges. Small minority. It was 99% of the transactions were subject to raised surcharges. In Dr. Lair's rerun, it was 96% of the transactions in Dr. Hubbard's own, the defendant's expert's own run. In putting that in, he said in his deposition, he was very fastidious. I am not saying that there's no relationship. I'm not saying that there's not the negative relationship. I'm only saying that the plaintiffs have not demonstrated. Well, Dr. Hubbard, have you given a good analysis? No, it pains me to say that my analysis is not a good analysis. We quote this in our, it's JA 7433-34 and 7458. Dr. Hubbard said he doesn't have a good analysis. Well, why do you have the analysis? It's really plaintiff's analysis, he said. I'm taking what plaintiffs would have done. And so then Dr. Lair, the economist for the Burke plaintiffs, comes back in rebuttal and points out the data that Dr. Hubbard selected was not at the ATM level. Dr. Lair in the rebuttal ran regressions at the ATM level and had statistically significant one-to-one relationship results. Dr. Lair points out that what Dr. Hubbard did was to take what's called ISOs, which are ATMs are coming in and coming out, coming in and coming out, month by month. The thing is changing. So then, while it's changing, Dr. Hubbard is averaging within these periods, and as the periods go forward, he still finds that 92% of the ATMs, which have 96% of the transactions, had the prices go up. Not the legal standard, it's just whether it's higher in a conspiracy. But he finds that, and Dr. Lair finds it's 99%. With it, and Dr. Lair's rebuttal says his analysis was doomed to fail. It was doomed to fail because he only looks up one level above the ATMs. There's all these mixes going on. He didn't say it's a miracle that it worked out in our favor, but it does reaffirm the industry-wide tax principle.
So we're not deciding this issue in the first instance. What do we do with the fact that there is language in the district court opinion referring to colorable method, referring to a critique of Professor, I know this is not your client, but referring to a critique of Professor Carlton's reliance only on Wells Fargo data as better suited for adjudication of plaintiff's injury and damage on the merits? What do we do with what seem to be, references to colorable method rather than, for example, a common method? How can we affirm if those are not legally correct?
What constitutes a hard look depends upon the disputes before the court. There's many other distinctions between rail freight and Comcast, as Your Honor mentioned, with the mismatch between the claims and what was shown. And Rail Freight One, which had the legacy contracts that couldn't have been subject to price fixing because they were made beforehand in the class. So we don't have any of that here. So what constitutes a hard look in this situation I say, I submit, your honors have to look at the decision compared to the record, and there is a finding, as your honors pointed out, Judge Bard, right at the beginning, that satisfies the standard. And there are infelicitous words that show up in a detailed analysis of going through what the judge thinks about three complicated cases. And this, so the law evolves, rail freight 2 happened. Now we're going on to a totally different fact situation where the judge did not use the exact right words, 2 points or 3 points in the opinion. So that's where the law is. And what are we going to do? Your honors know better than I, but I'll give, Judge Marrero has a law review article in the Cardozo Law Review. He's a district court judge in New York about how long it takes to do a complicated case nowadays. If the judge does not get rid of a complicated case in the district courts in New York, the judge is signing on for all these big, thick papers over and over. And the search for any problem with every ruling is intense because of the amount of money. And in my practice, which is class actions, I see that papers are put in where it seems to me the strategy of the defense is to provoke us to put in a long paper to rebut it. And it all adds to the district court's work. So maybe you could take that fact into consideration as a policy issue of what's going on in the courts.
Well, the problem, of course, is that district courts may have to work harder, but they've also got to comply with the standards that are applicable at the time they're deciding the case. And I think you make some nice arguments. And the question I keep thinking about in my mind is what counsel seem to be asking the appellate court here to do is to go through this very detailed analysis that you cannot find in the district court's opinion other than some sort of conclusory sentences with some examples, and giving the benefit to the district court, we try to read his opinion consonant with the correct law. And I guess at some point when the district court cites the standard in vitamins, and the law has just moved on since then, that is very troubling. If on remand, the district court were to reference the correct standard, it is not inconceivable to me that some of the analysis you and other counsel have suggested to this court today and in your briefs could still decide, having taken a hard look, to certify the class. And I know nobody wants to stretch this out further. Nobody wants to multiply the district court's burden. But I have seen appellate courts write opinions that say, well, the district court didn't say beyond a reasonable doubt, but he said it was pretty clear that the defendant was pretty guilty. You know, it's not good enough. Now, this isn't a criminal case, I understand, but there's a whole industry involved and major statutory provisions. So I guess that's where I'm troubled here. And I think a lot of the questions that Judge Pillard raised, you know, make some excellent points that Judge Edwards raised, make some excellent points, and then sort of what do we do now? And, you know, reading another judge's analysis about it's gotten very burdensome to be a district court judge these days because of the complexity of the cases. Well, try being on the Court of Appeals too. I don't think that helps us much, but that doesn't mean I don't think other parts of your argument have been, and of counsel, other counsel's arguments have been very helpful.
Well, Judge Rogers, I don't mean to shift the burden to this court, and I know that the more that the district court does, the better for this court. And the question is how to get there. In this case, how to decide this case and get to where you want to get. And you wouldn't want to, if you knew enough about the record without burdening yourself too much, you wouldn't want to throw the baby out with the bathwater. If the facts here are strongly in favor of the plaintiffs, it's just under the antitrust injury standard of paying higher amounts in the actual world than the but-for world when there's been a price fixing rule for 30 years, and where there is winnowing. Each one of these terminals has a number in the code. The winnowing, which is recognized by Rail Freight 2 as a way out of even the de minimis, but there is no de minimis. Dr. Hubbard does not offer the opinion there's a de minimis. Dr. Hubbard projects what he did as the plaintiff's work. It's not, but getting back to the main point, how to get there does not require, in this case, vacating or reversing. It requires, if your honors reach the state of mind that I'm arguing for, it requires us saying that you can't do this and you can't do this in the future, but the hard look that the judge took and the record, we're satisfied that in this case, there is not a class certification issue that doesn't have winnowing, that there's an error. There's an error in a couple of words. There's some dated words in the opinion for the reasoning, but when you apply the non-erroneous words, which are unqualifiedly correct resolutions of a very clear record, unlike the concessions in Rail Freight 2, Rail Freight 1, Comcast. But the expert in Comcast said, no, my model doesn't satisfy the only claim that happened. Now that the law's moved on, you're in this new fact situation. You don't have to, in my humble opinion, you don't have to reverse or vacate in order to fully do and give instructions to the district courts. I think I've gone over my time here.
All right. Yeah. Well, everybody did. And it's helpful to have your answers to our questions. We appreciate the guidance. I think we have, thank you, Mr. Lovell. We have a rebuttal from Mr. Anderson for the appellants. And Mr. Anderson did not have remaining time. He had requested 5 minutes. We'll give you 3.
Thank you, Your Honor. I'd like to begin with addressing the question of what should the court do. We've proposed that in light of what we consider to be the clarity of the evidence, there is uninjured class members in each class, and applying the appropriate legal standard, there's really nothing more for the district court to do. And in the interest of judicial economy, this court would simply reverse. It is certainly within the court's discretion. It concludes that the record is not as clear as MasterCard and Visa have presented, to vacate and remand to the district court or Judge Leon to do in the first instance what Rail Freight requires, which is to take a hard look at whether the classes presented models that can show common evidence establishes class-wide injury. As to the arguments that we've heard from plaintiffs' counsel as to why this court should not vacate, they were all presented in either Rail Freight 1 or Rail Freight 2. For example, I just heard Mr. Lovell argue that he can't be held to show class-wide injury with common proof because it's complicated, and our expert didn't come forward and disprove his theory. And both the Burke class and the independent operator class argued that absence of evidence doesn't indicate evidence of absence, shifting their burden to prove predominance to the defendants to disprove it. That was addressed in the first Rail Freight decision quite clearly, where this court said you can't shift the burden to defendants to disprove that common evidence can support injury. You need to come forward with common evidence showing class-wide injury. This is also not a battle of the experts, as the lawyer for Macklin was arguing. I did not, when I presented earlier, I did not argue what Dr. Hubbard showed. I described their model. Their model is a one-to-one relationship between decreases in net interchange and increases in surcharge. That's their theory, not Dr. Hubbard's theory. We then looked at data to see whether It is, in fact, the case that when net interchange goes down, surcharges go up. Dr. Hubbard found 15 banks where it didn't, and 13 where it didn't increase at all during the relevant time period, which was 2015. Who chose that time period? Professor Carlton, their expert. We used that time period because that's what their expert determined was appropriate based on, and I'll refer the court to Joint Appendix 3082, the fact that in 2010, there was a significant reduction in net interchange. That's why all of these cases were filed in 2011. And that's why the only question that is relevant here is what happened after that industry-wide reduction?
Well, they say something different. They say that there was a drop also in, I think it was 2006, 2007. Don't quote me if I conflict with what's in the record on that, but and that there was another raise in access fees earlier. So, and that the limitation to 2010 worked with the data they were using, but was distorting with the data that your expert was using. So, you know, without resolving that, those all are, according to the district court, issues that don't break the sort of general wholesale nature, yay or nay, of the issues presented down the road.
I understand, but they had an obligation to come forward with a model of injury. In Ralph Grade 2, the court said that in antitrust actions, common questions can't predominate. They can't predominate without reliable means of proving class-wide injury. They had to come forward with a model.
But that is something that Judge Leon held. He said they have standard and reliable means of showing class-wide injury.
You're right.
He didn't go in as much chapter and verse to explaining why that wasn't taken down by your counter evidence, but he did. He did make that determination.
Use words. But he didn't do the work, Your Honor. He was supposed to take a hard look at the evidence we presented, grapple with it, explain. He didn't just, and Judge Rogers mentioned that he announced the wrong standard in his decision. He didn't just announce the wrong standard, he applied the wrong standard. Every single paragraph of the 2 pages in his decision, where he explains why plaintiff's models were sufficient, refers to them as either, quote, tolerable, reasonable, well-established, well-accepted, tolerable, well accepted, tolerable. These are words that are not just in the stated standard that is incorrect. It
applies other words that are closer to what I think was the standard he was supposed to apply. And the fact that he didn't write an opinion that was 300 pages long is not critical here, it seems to me.
I agree.
And the question in my mind still is the legal standard he applied, and you know, some of the statements Judge Pillard was referring to. In addition, there are statements where the district court found that the plaintiffs could rely on reliable data, you know, that sort of thing. So, in any event,
Your Honor,
I think we understand this argument with all due respect.
with respect to the representative nature of the representatives of the data, Your Honor, you had asked about whether someone who banked at Citibank could rely on the Wells Fargo data to prove his or her injury. And that's exactly the right question. Under Tyson, you can come forward with representative evidence if any individual in the class could rely on that evidence to prove his or her case at trial. If you are someone who withdrew cash from a Citibank ATM that did not increase surcharge, you cannot come into court and say, well, they increased it over there at Wells Fargo.
But that is the underlying factual dispute, whether Citibank did not increase surcharge. And the plaintiffs are saying our evidence showed Citibank to increase surcharge off the end that you were looking at. And I understand that's you know, a dispute that remains pending, but whether it's susceptible of class-wide determination, you haven't made crystal clear to me why not.
Because how would you, based on the models?
I won't keep you. Why don't you wrap up and we'll take the case.
Based on the models that the plaintiffs put forward, what is the winnowing mechanism? How is the district court supposed to remove the class members who withdrew cash only from Citibank and all the other ATMs that didn't increase surcharges? No plaintiff has come forward with a model that says, plug this data in, plug this data in. And we'll see which expert is right, but if we're right that they all increase surcharges, that'll be fine. If defendants are right and the jury accepts evidence that some ATMs did not increase surcharges, plug that model in, we can whittle out the uninjured. They have not come forward with that. They reject that they even have the burden of it because they rely on a simplistic theory of injury, which is 1-to-1. And they've had 10 years to develop it. They've had full access to discovery, and they have the assistance of able counsel and a talented economist. And that was what they submitted. That is insufficient under rail freight. This court should reverse the district court's decision. Thank you.
Thank you so much.